everybody, and welcome. Thank you so much for joining us today on this webinar where we're going to invite guest attorney Al Nicoletti, who's going to be helping us understand the Florida probate world. And we're so excited to have him today, and I'll introduce him in just a second. My name is Larissa Green. I'm with Advanta IRA, and before we get started into probate, I just wanted to give you guys some information on myself and Advanta in case you're not familiar with Advanta. Again, my name is Larissa. I've been with Advanta IRA for almost 10 years now, and I work in business development, education, marketing. That's sort of my wheelhouse at Advanta. And what I do for my firm is basically get out there, network, and introduce people to the idea of self-directed IRAs. And I also handle a lot of the education here, and that's actually how I met Al. I was at a local investment club where he was speaking on probate, and I just thought the topic was so great, and I thought so many people could benefit from learning a little bit more about probate, because I honestly really didn't know anything about it. And of course, you hear all those scary stories about how long the probate process works, and Al really cleared up a lot of the confusion I had on that. So we definitely had to have him on here. So I'm so happy to have him. I included my contact information in here for you guys, and I'm only going to talk just a quick minute about self-directed IRAs and how they work so that you have an idea. And if you have questions on self-directed accounts, I'd be happy to answer those. Just reach out to me here at the extension listed, or you can send me an email. I also want to mention before we get started that I do keep everybody muted, so everybody will be muted on this call. But if you have questions, please type them into the question box, and Al will be answering questions occasionally throughout the webinar. And if we have time again at the end, it just makes it a cleaner recording, and then that way we can get to the questions in a timely manner as well. So just a quick disclaimer for you guys, Advanta IRA and its employees do not provide investment advice. We don't provide legal or tax advice either. What we're here to do for you is educate you on self-directed IRAs and how they work. If you have a question that falls into legal, tax, or investment, and you're not sure if we can answer it for you, please ask it anyways, and we'd be happy to direct you to a professional that has helped our clients in the past with these types of questions. But if you've attended our webinars in the past, you know we talk a lot about strategies people use for self-directed IRAs, and we're always happy to answer those questions for you. Advanta IRA has been in business for almost 20 years, and we can help anybody nationwide with a self-directed IRA. We can also help those people that are outside of the U.S. as long as they have a U.S.-based retirement account. And so we're here in the Tampa Bay area of Florida, and then we are also our other office, which is a marketing and business development office, is in Atlanta, Georgia. But again, we can help anyone nationwide, and we also do a lot of our webinars and seminars out of both offices. And so for those of you that have joined us for our networking events in the past, you know that they're hosted by myself and my partner here in Tampa Bay, and then Renika Laybourne and Clay Malcolm in our Atlanta, Georgia office. And if you haven't joined us for our Zoom networking events, I would encourage you to do so. They have been a great way for us to get together even when we can't get together. And if you want more information on those, you can go to advantaira.com/events. And the next one is this Friday, January 29th at noon Eastern time. What is a self-directed IRA? I think that's very important, and I'm only going to cover it again very briefly, and then we're going to bring Al on. But a self-directed IRA is basically an IRA account that allows you to invest outside of the market. So our definition of a self-directed account is actually something very specific. I often meet people who say, well, I have a self-directed account. I can invest through my brokerage firm in those investments that I want to make, and I can trade them when I want to and purchase the amount I want to. But our definition is very, very specific, where we actually don't hold anything market-based at all. Our clients are all making private investments. So they're buying real estate, they're investing in real estate options, tax liens, and deeds. They're investing in private assets like private stock, for example. I have a lot of clients that are invested in their local area into local businesses like breweries and private bank stock, things that you wouldn't think about not being allowed at your brokerage firm, but they actually typically brokerage firms are not holding these private investments. And so we're really not competing with your brokerage firm. We're simply filling the gap in the industry so that you can make those private investments that you see best. So like I said, we have a lot of clients, actually real estate is the #1 investment that we see. And so it could be buy and hold real estate. For example, if you like to invest in single family homes, you can certainly do that with a self-directed IRA. You can invest in what we sort of consider the paper side of those assets, like tax liens, real estate options. It could also be a private mortgage, for example. It could be a first, second, or third position mortgage, whatever it is that you're comfortable with. You would let us know and we would help you get it done in the name of the IRA. We also see things like precious metals, foreign currency exchange. We're also seeing a lot of interest in cryptocurrencies, oil and gas investments, equipment leasing like farm equipment. I have also seen large format printers and ATM machines. I mentioned private lending. But really the list goes on. And just again, important to keep in mind that we don't sell any investments at all. We simply hold the account, you find the investment, and then we help you get it done in the name of the retirement account. So there are some rules involved in self-directing your account, just like everything else the IRS says. There are things you can and can't do, so you do want to be aware of those rules. And we address those on a lot of our other webinars. So again, I'm not going to take up too much time talking about it today. But just so that you're aware, and if you're interested in self-directing and you're not, you don't necessarily understand or know the rules, then please, I would encourage you to join us for future webinars and check out our past webinars on YouTube so that you can kind of see how those investments work within the retirement account. So with that, I'm going to turn it over to Al, and thank you so much, Al, for joining us. How are you doing today?
Larissa, thank you so much for having me. When we met, like 2 months ago, and you let me know about this webinar, I was all in from the get-go. So thank you so much for having me on this. And I need to learn a little bit more about self-directed IRAs after you were talking about that. I'm not educated on that, so I'll come to you for those things.
That sounds good. Thanks, Al.
All right, Larissa. So, hey, everybody. My name is Al Nicoletti. I'm an attorney here, licensed in Florida only. I'm not licensed in any other state. And Larissa, thank you for having me on this. I do a lot of probate. I do different types of real estate litigation. I'm not a title company. I get very nichey when it comes to the real estate probate world. And what Larissa saw me do about 2 months ago was really dive deep on the world of probate real estate. But in the world of probate, it's not just about real estate. There can be bank accounts, there can be brokerage accounts, IRAs, different ways that there could be a probate situation. And we'll dive in on some of those things. But at the end of the day, what I want you to learn from this is that this is just going to be a basic understanding of the probate world with some maybe a little bit of trust and estate planning. Very little, but very basic. I'm not a CPA. I don't do any tax work, so I don't know any specific things on that. But I just want to give you a basic understanding of this probate world. And I'm going to find a way to make sure I can change the slide, Larissa. All right. So I got it right here. Again, you can reach me at my email. That's the phone number, the office number. And where you can also reach me is and find me, because I post a lot of videos, is on Facebook at Al Nicoletti. Seeing something pop up on that screen. All right, there we go. So you can find me on my Facebook page at Al Nicoletti. I have a new show which I'll talk about, but I talk about things with probate, real estate, different things, bringing different people on, always posting content. So find me on my Facebook page. Also, you can find me on my YouTube channel at Al Nicoletti, and I'm posting different things on probate, quiet title, partitions, different real estate things. And also, I have my new show out called The Al Nicoletti Show, where I dive deep into real estate investing and business in the state of Florida. I am interviewing movers and shakers, rising rock stars, and big people in the Florida real estate community. And you can find it on iTunes, you can find it on Spotify, and the videos get played on YouTube, LinkedIn, and Facebook, where there's micro content with quote cards. So make sure you check out my new show. You can subscribe to it on iTunes. Yes, it's already there under The Al Nicoletti Show. I'm always interviewing somebody different, unique. It's not all about me on that show. It's about interviewing these guests. So you may want to check that out. I'm having a new studio soon. So as soon as I do, it'll be a combination of me being on. I do webinars live every every month. I think it's going to be every second Wednesday at like 7 p.m. I'm doing a different unique webinar. So make sure you check that out. Make sure you subscribe, and we're diving deep. So if you have questions, I think Larissa, we talked about it. If somebody has something pertinent to what I'm going over, we may be able to answer it. But if you want and you want to keep going through the presentation, you can always ask the comments or share stories or questions at the end. So a comment I get a lot, and so we understand what probate even is, because I can't talk about probate without you understanding what it is. It's all about title and the name of the deceased person on the title. It can be a house on the deed with the person being on the deed. It could be a bank account, the person that dies on the bank account only, no beneficiary designation. It could be a brokerage account for the stocks or whatever you're doing. It can be an IRA, but there's no beneficiary designation. All it is a court proceeding just transferring the title to who the true heirs are. Maybe it's by a will, maybe it's by no will, and we'll talk about the differences. But all we're doing here is transferring the title. When it comes to real estate, that's why I have here, you cannot transfer title, sell, convey, or mortgage, and no quitclaim deed without the probate being done. That's all it is. So all the books out there that you see, the WebMD self-diagnosis, they make it really complicated, and they tell you all of these words and terms. I had slides on here before the presentation I was going to put, but when it comes to doing these timely, I get these done rather fast, not like 12 months to 2 years. Sometimes these things can be done in weeks. But why you have to do probate in the real estate world, so you understand that, is there's something called title insurance. And title insurance, when you bring that contract with a buyer and a seller to the title company, they'll bring it to the insurance company. And then when the insurance company does the forensic examination of what's on title, they won't issue a buyer's policy to the new buyer unless the probate is done in Florida. Yes, it's different in different states. Texas has got like an affidavit of heirship. I've heard different things in Georgia for sure. Every state's different when it comes to probate. But in Florida, when you see somebody on title and it's in their individual name and they died and there's nobody else named as beneficiary, or there's no ladybird deed, life estate deed, there needs to be this probate that transfers the title over. And yeah, like I said, title insurance plays a really big role. And then I switched to this slide because it's an eye opener about where things are headed with this whole probate thing, right? So you have to know what probate is to understand why it's going to be such a big thing later on. Well, right now we're in 2020, right? And so we're heading to 2030 and 2040. And by that time, the baby boomer era is getting really big. So I'll show you the stats, but the baby boomers are starting to have, like, I think it was like Zillow said, a million homes, owning a million homes every year. It just keeps increasing and increasing, and they call it the silver tsunami. And the reason is because that baby boomer generation by the 2030s and 2040s is going to be a large portion of the United States, and especially in Florida. And the importance there is making sure that you have your estate plans together, making sure that you understand that probate is not a nightmare, even if it does come up. And we'll talk about trust, but we're heading to this point where you have to understand that it doesn't have to be a nightmare. And also you can have your documents prepared, or your family members could have it prepared. So this whole thing that's coming is just adding up. And you can see here, by 27 to 2037, almost 1.17 million homes per year are going to be baby boomer owned. I mean, 40% is going to be over 60. So we're heading to this crazy era of not just real estate, but also those people that are baby boomers that have real estate also have stocks and bank accounts and IRAs. So very important that if you do have an IRA, you do put a beneficiary designation, right? So by virtue of your death, unless it goes into a trust, if you have a beneficiary designated on your accounts, bank accounts, IRAs, brokerages, it bypasses probate. So if you're looking to bypass probate to make sure your children, your heirs, whoever they are, don't have to go through the wackadoodle situation that you've always heard takes forever and is complicated, you can name those people on the IRA on a beneficiary designation. So these are just probate stats for real estate, and I want to show you this. This is why it's so big in Florida, because the amount of baby boomers that are here, Tampa, Miami, and Orlando rank in the top 4 as the biggest areas that probate is going to be a problem, well, or probate's just going to be popular, because so many people are also moving to Florida, and making sure that you have the properties titled in your names, maybe as a life estate deed or in a trust, is important, because there's just so much real estate here in Florida. So let me get that slide. There it is. So is it going to go? Okay. And these are real stats, so you understand. These are real stats out there that talk about the importance of estate planning and the importance of knowing that there's a probate world coming, even more than now, right? So probate is big right now in Florida, but it's only going to increase. And by 2037, you have a third of the inventory in Florida, just in Tampa alone, going to be owned by baby boomers. So those baby boomers, again, don't just have real estate, but they have bank accounts, they have trusts, they have other types of assets that if they don't plan for it and they don't do what they need to do, they're going to have to go through probate. But probate isn't a bad, dirty word. It can be done efficiently if you have if everybody's on board and you have the right estate planning documents all together. Now, I talk about this on this slide here that people don't realize. So um, if I was in a crowd in front of a bunch of people, I would ask you, when was the last time, and I'm talking Florida here, but you got to get with attorneys in other states too. But if I asked you, how many of you here, when was the last, and if are you on the deed? And the point about that is, if you look at your deed in Florida and you're married and your spouse is the only one on the deed and you are not on the deed and your spouse dies, you're thinking, oh, it's okay. I was married to that person. I can sell the property now without any issues. What happens is you bring it to title, and title says you can't sell it without doing a probate. And the reason is because of the Florida homestead laws that go down in a chart that say you weren't on title, you get an interest, whether it's a life estate or it's an equal interest with any children if they're surviving. It gets weird with Florida, but the point that I'm trying to make here is that it's all about title and who's on title to the property. Maybe it's the bank account, right? So husband and spouse are on the bank account together. Husband dies, well, you don't need to do probate for that bank account because it's going to go to spouse. But if husband's the only one on that bank account, the only one on the IRA, and also the spouse is not named as a beneficiary or also on title to that account, they're going to need to go through probate. So that's why that it says there only husband or only wife's name on a deed. And it's crazy. And people can't believe it. They'll go to title, they'll get under contract with a buyer, they'll go to the title company, and title company will say, yep, you got to do probate. And they're always saying, no, I was married to that spouse. Why do I have to go through probate? And it's because it's about title. If you're not on the title, there's going to be issues, and a probate is going to be needed. So the different ways, there's 4 different ways in Florida that, and I'm sure there's a couple others, but there's different ways that probate is avoided. So you don't have to go through this formal court process of a judge looking at everything and saying, yep, this was the deceased. Yes, these are the heirs. I'm signing this order. Avoiding that, which again, it doesn't have to be a nightmare in Florida. It can actually be a simple and easy, understandable process, is these tenancies. So you can have a deed in Florida real estate wise titled as tenancy by the entirety. So what does that mean? It's husband and wife. If you're married, check your deeds on if you're in Florida, because if you're married, it should say husband and wife, and then it should say as husband, as wife, with tenancy by the entireties. It could just say, John and Sally married, or as husband and wife, which is okay. But it's always good to have the language in there, making sure it's not just John and Sally. There could be a lot of title issues if you bought the property together before you were married and never changed the deed. Crazy stuff that I saw last year. There was one story where I didn't know we had to do probate. I had never seen it before, where this couple bought the real estate before they got married. They never changed the title on the deeds. They never retitled it with the title company. Both eventually died. And so when the title company said, yes, we have to do probate, I thought, well, wait a second, they were married, and can't you just use a continuous marriage affidavit with your title stuff and that'll solve it? And title said, well, normally maybe, except for the fact that the wife had 2 children from a prior relationship and the husband had 2 children from another prior relationship. So that changed the whole perspective on, yeah, we kind of need to do probate here because there's going to be some questions from heirs. So very important that things are titled the right way. Also, joint tenants with the rights of survivorship rarely comes up. I mean, I've seen it before. It doesn't come up as much as people think, but what it is the way that it's deeded, the title on the property, it says John and Sally as joint tenants with the rights of survivorship. It almost has the same function of a husband and wife situation, where if John dies, Sally records a death certificate, she's the owner. Um, or you can have John, Sally, Sue, and Mike, and it says that language of joint tenants with the rights of survivorship. What it really is in Florida is survival of the fittest, right? So whoever lives the longest eventually gets the title to the property. And you see it once in a while and it comes up. Also, ladybird deeds. Ladybird deeds are very popular, or life estate deeds are popular in Florida. A life estate deed and a ladybird enhanced life estate deed are a little different in terms of the real estate world. But what it is if that person, let's say John, owns the property, he's not married, he just has 2 kids. Let's go with that. John owns the property. He redoes the title to his deed, goes to the title company. They do a new deed called life estate deed. And he says, I want to make sure my children avoid probate. So he retitles that deed. On the deed, he names his 2 children as beneficiary. So if he dies upon the recording of a death certificate, the title immediately shifts over to the 2 beneficiaries and there's no probate needed. Now, the only downside to the life estate deed is if John does that and retitles it and later wants to sell the property, he needs the consent of the 2 children to eventually sell the real estate. But if he does what they call an enhanced life estate deed, the ladybird deed, the way that the language is in the deed, if John retitles it to the enhanced life estate, leaving it to the 2 children, and eventually he's like, yeah, I don't want them getting the property. I want to make sure I do something else with it, or I devise it to somebody else. Let's just say also they're adults too. The upside to that is that he can revoke it at any point while he's alive. And if he did want to sell the real estate, he technically doesn't need their consent to do it. So it's a weird tool in Florida when it comes to estate planning. Also, revocable and irrevocable trusts. I have some slides on this that's kind of interesting. So trusts avoid probate. Poorly drafted trusts do not avoid a court administration thing. So what do I mean by that? And I think I'm going to talk about that on the next slide. So this is a popular question, and it doesn't come up as much as probate does, but I think I have this here so that you understand. Make sure when you're doing trust or you go to an attorney for your trusts that it is complete and contemplated and thoroughly thought through. Because what happens is if the trust is missing terms, is missing successor trustees, we'll talk about that at the end. A crazy story I had in Florida. But if you're missing terms, what happens is what happens later when you die and the beneficiaries need to determine when is the distribution, how much is the distribution when I turn this age or this age or this year, or what happens with things, who's the successor trustee named if this one doesn't want to serve? Are we then going to have to go back to the court and ask who can be a successor trustee? So we've seen situations where, sure, the property was titled in a revocable, irrevocable trust. And this usually happens with irrevocable trust because that person has now died, and really the person that created the trust can't change it because they're deceased. But you have situations where if you have missing terms, it can be a problem. Or maybe what happens if the trust has people that or beneficiaries that conflict with each other. This happens from time to time, and there needs to be what they call this court administration. It gets pricey, it gets long sometimes, or it can be quick when it comes to real estate. But know that a trust definitely becomes irrevocable upon that person's death. So if it was John Smith and he created a revocable trust dated 1979, and he dies, now that trust becomes irrevocable, and certain things that need to be changed in the trust must go before a court to ask the court to change it under judicial supervision. Yeah, you can't change it without court sometimes. So, like I said, one of the big things that you have to understand is that trusts should be properly drafted, meaning they're contemplated and thought through. When you do your trust, you have to think through, who do you want to name as the next trustee, the second to next trustee, the third trustee successor, the fourth trustee successor. Because if you don't name anybody there, then it could be a situation of maybe the beneficiaries both have to be appointed later on. And maybe you didn't want that situation. You didn't want Sally and Sue to have a dispute about who's going to be the new trustee. It's just important to contemplate who you want next to be there to avoid some kind of court thing. If you notice here, understanding the probate world is also understanding the trust world, because just when you thought trust, you're out, you don't have to deal with any court, you may. And that's why they go hand in hand. You're going basically before the same judges that look at this stuff. So knowing those steps, 95% of people, I think that was the last stat I heard, 95% of people don't have estate plans. Yeah, they have their bank account set up with beneficiary designations, but they don't have things set up like trusts and HIPAAs and living wills and wills. They just don't. And so things just go by statute, and they go to people that maybe you didn't want it to go to. So just know, you don't have to know everything about what is this thing, what is all this trust admin. Just know that it's very important to have everything in order for yourself when you do this. Is there a will? And I only have testate here because that's the kind of probate it is. When you have a will and you do a will, know that the will still has to go through a probate proceeding. So just because you do a will in Florida, for sure, I don't know other states, but just because you do a will doesn't mean you're avoiding going, your beneficiaries are not going to be able to go to court. They're going to have to go to court. It's just you picking who you want your stuff to go to. So they're not avoiding any kind of probate. Wills can say people get stuff, or the will can say a trust gets stuff. That is up to what you decide what you want to do with your assets. But it's very important that you either let the attorney that drafts the will to hold on to the original, or you hold on to the original, but somebody's got to have the original, because the original ink document is very important to avoid issues later on with the court. You can have copies of wills, but now you have a very complicated proceeding, and you have to track down the witnesses, you have to track down the notary to basically say, yes, this is, you have to prove that there was a will. You have to prove that there was a sit down of everybody signing it. It gets complicated. So very important, you keep the original will, or you keep it with a custodian that knows where it is, or your beneficiaries know where it is. I had a mentor of mine tell me that one of the best places he could keep his stuff is in the freezer, because if the house burns down, I don't think the fridge is going anywhere. So, but you do with what you want with the estate planning documents. There's no rhyme or reason to where you can keep them. Just make sure you keep them safe, and you always need the original one. And also, I'll say this: the more I do probate, the weirder I see things. So I've been seeing lately where there's been some handwritten wills on notebook paper. I'm not making this up. I think it was the second or third time I've seen this in the last year. It was on notebook paper, one page. There was, on one of them, there was one witness, and then just a notary. And then on another one, there were like two witnesses and a notary. but nothing was self-proving. And in Florida, for wills to be admitted with no problems or the least amount of problems, it has to be self-proving, meaning there's an additional signature page on the back that talks about that there were two witnesses. They all saw each other looking at everybody with the testator and the notary. It's almost like they witnessed on the first page with the notary. There's witnesses, the person that signed it, and then the second page that they all looked at each other. It's like a double confirmation. That is important to know. I've just been seeing so much of this, like I haven't seen one on a napkin yet, but it looks like it's pretty close to seeing one of those. You have to make sure that it's done properly. Going with the right people to make sure it's done properly is very important. And like I said, wills do not avoid probate. In Florida, wills do not avoid probate. If there is a will, that person dies, at some point there's gonna have to be some kind of probate, unless they seriously got everything set up perfectly with beneficiary designations, ladybird life estate deeds, and nothing has to go through probate. Then I mean, unless there's something specific in the will that they wanted somebody to inherit, it's not going to be needed if they have all of that set up. But many people just don't have all of that set up and contemplate that for what they want after they die. And wills guide the probate process. Wills are all they're doing is telling the court where things go and how things go. And actually, for this webinar, and I dropped this in, Larissa, for everybody to see. When you're creating your wills, it, again, like I said with trust, it's very important that when you do estate planning documents, you contemplate the next, the next, because what you don't want a situation of is you name one person and then that person predeceases or dies, but there's no in who, and then it becomes complicated about who's next in line as an interested beneficiary. Are they going to be fighting about this? You want to avoid as much conflict as possible. So there's a clause, and there's other specific clauses too. It's not just the rest, residue, and remainder. There's also other clauses. So make sure if you're in Florida, you get with a licensed attorney. Yes, we do estate planning here. I don't do it personally, but we, in the law firm, I have an attorney, Jeff Bankston, that does the estate planning here. So we always make sure, depending on the provision of what somebody wants, that it's thorough. For this situation, I want it to go here, but in the event somebody fails to survive me, I want it to go to this person. And also, I see per stirpes here. Very important to understand the concept of the per stirpes, that if a lineal descendant, and this is no will too, but if that lineal descendant could die, if you don't have this contemplated, if you have none of this contemplated in the will, if you have no will and one of your beneficiaries predeceases you, their children, their lineal descendants, if living, could inherit from it. Crazy how the scenario works. I'll talk about two scenarios that happened that was just crazy. It was just wild stories. But again, just another reminder about the importance of making sure that somebody else's name there. Also, and this is another clause about real and personal property, that you're contemplating who's getting what and what's getting what. Maybe it's going to a trust. It's pretty important that you have that there. I don't think I
Hey,
jumped
Al.
too far. Yeah, yeah.
Yeah, I just had a quick question because you said, okay, so wills do not avoid the probate process. However, do you see that if there's a will in place, sort of describing how the property should be inherited, does that typically make the probate process much faster and easier than, because even if there was an argument or dispute among heirs, it would really sort of be solidified by the will?
Um, so if the will is contemplating and saying, let's just say there's four kids and John's one of them, but the will is saying John gets the property and then the others don't, then yeah, I mean there could be provisions that lay out who gets what and who doesn't get what, or is John getting it? Is Sally also getting it? Or is it saying that John and Sally, upon my death, John and Sally shall inherit the property but sell it within 30 days? I don't know if that answers your question, but wills can lay out very specific instructions about what happens upon that person's death.
But I guess the heirs could still argue it and it could still drag out the process.
Well, in terms of execution, undue influence, with a will, I almost had a case one time where the person that died was deemed incompetent by the court. And 2 days later, there is a will executed by that person. So there would have to be substantial facts to show that that person maybe didn't have the capacity to sign that, or to try to say that there weren't witnesses or question the validity of the will. Sure, there could be different types of causes of action to contest a will. Not everyone stands, but there could be ways that it can be contested.
Okay.
But I rarely see things like that. Like, we had one that was really crazy. I think it was like 10 beneficiaries. Nobody got along. Surprise. And then there was like two PRs, and it was just convoluted. It was just nobody just got along. There were minor beneficiaries, and they couldn't figure out why one of the beneficiaries was getting a life estate to the house, and then why they were getting a remainder. Why was she getting the house? So they challenged it, they contested it, and we eventually took on the case, but we brought it to mediation because at the end of the day, everybody was trying to get something, and where the case was moving was somebody was going to get nothing, and then the rest were going to get something. So everybody saw the big picture about, man, well, maybe we should get something rather than nothing. So I've seen plenty of situations where, I wouldn't say all plenty, but I've seen situations where there can be a contest to the will. Like, we even have one where we're about to do, the ex-spouse is named as the personal representative, and or no, she's not named as PR, she's named as a beneficiary. And so the question is whether she can be a personal representative. So we have seen some weird stuff, Larissa.
Okay, gotcha, gotcha. And then I did have two questions pop up here. One is asking about an explanation on forced heirship.
So I don't know anything about forced heirship. That may be in a different state. That's not familiar to me in Florida. Um, I yeah, I'm not sure about that one.
Okay, okay. And then another question is, what happens if the real property still has a mortgage? I'm assuming they have to take it subject to the mortgage, but maybe you could fill us in on that.
Well, what they can do is, if they wanted to sell the property and the contract price, if the heirs wanted to sell and the contract price exceeded the mortgage, they could sell the property and the mortgage company gets paid off. Um, or if they wanted to keep the property, at least in the probate world, you notify the mortgage company that there is a probate proceeding ongoing, that the purpose of the probate is to transfer title from the deceased to the heirs. And after that, there may be a way that one of the heirs or all the heirs can do a refinance on the property now that title's in their own name. Like, maybe Wells Fargo had the mortgage, but they get a approval on a refinance from Fifth Third Bank to do now a new mortgage, a new loan. Um, Whoever's on the note is responsible for paying the debt, and the beneficiaries, if they're not on that note, there's no obligation to pay the debt, but they're still going to, a mortgage company can still proceed with a foreclosure. I mean, if they really wanted to, a mortgage company could call the loan due even though the probate got done. So there's different ways it can go with the mortgage.
Okay, so they would have to work with the mortgage company to make sure that they either refinance it in their name or that they work out something with the mortgage company to maybe assume the mortgage once the
If they
probate
keep
is
it.
complete.
Yeah, if they keep it.
Okay. And
If
then one more question.
if
Is there a
if they,
statute? Go ahead.
if they sell it, Larissa, if they sell it, they don't have to do anything with the mortgage company.
Okay, gotcha, gotcha. And then is there a statute of limitations on contesting a will?
Actually, I think there is in Florida. I'd have to look up what that timeline is. Yeah, we saw that recently. I don't know the exact date, but oh yeah, there was a statute of limitations, and it wasn't. I don't even think it was a year. I don't think it was a year. I think it was like less than a year, but you have to be careful about that. Yeah, we saw that recently. Now on a trust, that's interesting in Florida. On a trust, I don't know if there was a time period on which to contest a trust being executed. I assume there would be some kind of thing that would apply, but yeah, when it comes to wills, I think there's a certain time period within which to contest it.
Okay, great. Thank you. Thanks, Al.
Yeah, that's great questions, Larissa. I mean, they're relevant. They come up in the probate world. So I'll continue in what we're doing. Let me go forward. Is there a way to get that?
Yeah, sorry, I took that off. There you go.
Okay. All right. So in the world of probate and wills, um, in Florida, you can designate who would be the personal representative. In other states, it's called executor, administrator, administratrix, whatever it is. In the world of Florida, it's called personal representative. There doesn't always have to be a personal representative appointed in the probate, but in terms of the estate planning documents, it's good to name who you would want to represent the estate, who you want nominated as the preference to represent the estate in the event there was a probate. Just know it's a person that, if appointed or if needed by the court or to be in the probate, they are representing, and they have duties. They have so many duties to preserve, duties to marshal assets and collect all the assets of the estate, and just a duty to administer the estate prudently. It's just an important role on a probate in a probate estate. So that's one. And then slide. So here's where it gets crazy. In Florida, if you don't have a will, you don't have a trust, everything is solely in your own name, no beneficiary designations for anything. This is called really understanding the probate world, because a lot of people don't have wills, don't have estate planning documents or trusts. So what happens when they die without a will? They are the beneficiaries, whoever they are. It goes down a certain line.
Al?
Basically, is it going?
Yeah, we lost you for just a second.
Okay. Let me go back. I'm giving everybody too much of a sneak peek. Okay, there we go. And if there's no will in Florida, Florida basically by statute has one for you, meaning that it lays out who inherits and who's next in line. So there's a whole inheritance line that is followed, and in Florida, a spouse has massive rights. You cannot exclude a spouse from getting something in Florida. So if you try to write out the spouse on a will and you're married, that spouse can still take 30% of the estate. There's a lot about spouses. So spouses have huge rights. So you always find out, like, if that person dies, were they survived by a spouse? All right, let's just say that there's no spouse. The next thing you look at is who's inheriting next is children. That line, if one of them are deceased, then you look at their grandchildren, but basically it goes down a lineage line. No, not everybody in that line, if everybody's alive, is inheriting. It really starts first at children, then it goes to grandchildren, great grandchildren. But if there's 4 children of that person that died and they're all alive, it's just going to the children. It's not going to the grandchildren, but it's going down a line, so that everybody understands. And then if there's none of those, it goes up to parents, grandparents, great grandparents. And then if none of those, it goes out to brothers and sisters, nieces and nephews. There's a whole inheritance line. It keeps going. And at some point, if you can't find any of the above, you eventually we have a genealogist. I know a great genealogist. It's crazy. He performs a full blown genealogist search and would even do an affidavit as to his findings too. It's crazy. So it eventually you can start looking at the spouse's family line also if married. So just know that if you don't do your estate planning and you don't leave it to the people you want to, Florida defaults who it's going to be going to. So that is the key here, and that's why it plays a big role in real estate, and that's why I was talking about that with Larissa at the last seminar I was doing in Tampa as it relates to real estate. It plays a role, you know, who's next in line, who can sign the real estate contracts, who is title going to go to, who does the homestead property eventually vest to, because homestead is a whole other topic on its own when it comes to real estate, about, you know, who's next in line to inherit, what happens with homestead, what does homestead mean? I can't remember if I dropped it in here, but we may cover it. Oh, there it is. So homestead in Florida is really important. In the world of probate for homestead, it's not about whether that person applied for the tax exemption. Great, that's a great indice or evidence that that was their homestead, but it doesn't have to be. It's all about, for homestead, that place, the actual intention to permanently live in a place and reside. They intended to live there. And that's happened several times where the person lived there, they got sick, they went out of state for 9 months. And the question became, if they got well and they stood right back up and walked out the door, would they go straight back to this primary residence? And many times it's yes, they would. They would go back home. They don't want to be where they're at, and that's the homestead. It's about the permanent place that they wanted to live and reside. And homestead property in Florida, depending on the acreage, it gets deep, but depending on the acreage for within a municipality and outside a municipality, but it can be exempt from most creditors. Most creditors. There's certain creditors that they'll have a claim. Mortgages aren't going away. Uncle Sam IRS stuff is not going away. Major improvements and, you know, security interest to the property are not going away. Though they're recorded there, they just are going to attach to homestead property and are considered creditors. So even if that person died more than 2 years after death, yeah, the creditors, many creditors like Visa, MasterCard, Home Depot, Comcast are out. That mortgage is still sitting, what, 10 years later, it's still going to be valid. So just know that homestead plays a major role in what's happening. And also when it comes to real estate, the homestead property, if ever sold, that homestead property has to be sold by all the beneficiaries. They're the ones that are in that line or the ones that are named. It's just important, not only for homestead purposes, but for title insurance, that all heirs are on the contract, the heirs sign the probate documents, and eventually in homestead property, the title company is going to require a deeds to be signed by all the beneficiaries. And also I heard this story recently. It was absolutely crazy. I don't know where it was. I think it was in Florida, but there was one probate I'm not working on, but I heard the story. Guy dies. It was his primary residence. And what they found out was that there's 25 beneficiaries, and they all survived that guy. So there was no questions about predeceasing and per stirpes and lineal descendants. They all outlived this guy. No will, no trust, no nothing, no ladybird deed. And so what happened was, they were all the buyers with the title company. They were all ready to close, and there was a personal representative appointed by the judge. So there was a personal representative. And the title company said, oh, yeah. You all we need is the personal representative to sign the contract and the closing docs, and you're good to go. Well, I learned a thing or two, and I know Larissa did at the last webinar, that if it's homestead property, you can't have just a personal representative sign. All heirs are going to be needed on that contract, and all the heirs have to sign the closing documents. So what happened 2 months later, title insurance tells the buyers, oh, you need all 25 to sign the deeds. We'll start preparing them. And they said, what? I thought we had just the PR to sign this. Then they come to find out that 2 more of the beneficiaries died within those 2 months. So great, they could have had the deed signed by everybody, maybe gotten the deal done. Now there has to be 2 more probates for 2 more people that died. This is why it is so important that if you have those situations and that many beneficiaries, that you have your estate plan together, because it is a mess. And I'm not working on it. I have no idea what the timeline is on that, but I can tell you that it's probably not going to be about 3 to 6 months before something like that closes at the title company. So just crazy stories when it comes to homestead and the importance of it. Also, a little tidbit too, understanding the probate world and power of attorneys. Making sure the power of attorneys are detailed and allow for what you want it to allow. Do you want it to allow for a real estate transaction when you become incompetent? So there's power of attorneys and there's durable power of attorneys. Durable power of attorneys means it lasts even when your faculties, your mind goes out. So and it's important to know the differences. But the critical part for probate and real estate is that having the original POA, the power of attorney, is needed because the title insurance underwriters want them. And not only that, you may find some institutions, banking institutions, brokerages, who knows if it's Charles Schwab, Vanguard, any one of those institutions that may need an original power of attorney. Very important that somebody has that. Sure, there's times when the copy can be good, but very important that original POAs are preserved and saved, especially for title and real estate. Had a situation, I'll talk about it at the end, but it was just wild. I'll save it for the end. So this is what was crazy about the successor trustee part that I was talking about. At the end of the day, when it comes to real estate, it's all about who has the authority to sign the documents. So a trustee, if alive, a trustee for that trust can have the authority to sign the documents for the contract or for title. But what happens when the person that created the trust names only one company, a corporation, and names nobody else, and then that guy dies? And then the guarantee company comes back and says, we want nothing to do with this. We don't want to have anything to do with this. And it's just crazy because it just happens. You have to name a new trustee. You have to name somebody else that is named as a trustee. And it's very important that you contemplate this, because when the title, I'm sure none of you, maybe some of you, many of you have never even seen what a title commitment is. And the more Larissa hears me talk about this, she'll know what a title commitment is and see one. But there's very important requirements when it comes to a sale of real estate. And you'll see number 4, it'll talk about how if there was somebody named on a trust, it would have the name John Smith, successor trustee, Sally Sue, successor trustee. So it's very, very important to have people named. I mean, these are real situations. So this guy died back in like 1990, and the heirs just held on to the property for 30 years, paying the taxes. Eventually wanted to sell it. They brought it to the title company and said, whoa, 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 you need to do this kind of trust administration to get a successor trustee appointed. Well, you can imagine how not happy they were, because this should have been solved back. Am I still there?
Yeah, yeah.
I'm still here? You lost me? All right. But the important part is what happens when this goes wrong. Just know that that's the important side to this. Is it changing?
Yes, you're good.
Okay. And yeah, and there's different reasons and ways that trusts get modified. Maybe maybe that there needs to be an extension of how long the trust lasts, or the provisions and the distributions, or maybe there needs to be trust terms in there that talk about specific language for maybe a refinance on a loan, or just but just know that there's different ways that trusts need to be modified or terminated or changed, that come up. And so you're thinking, oh, I did my trust, I don't ever have to do anything again. Think again, because you may have to, depending on what terms were contemplated. Maybe the trustee no longer exists and you have to redo the estate plan. Not a successor trustee wasn't named. We saw one where the trust, the trust had a distribution provision in it, but a whole paragraph was deleted about, when it happens, and there had to be a full court proceeding about when it happened, and the judge had to, there had to be evidence about what the person intended. There was testimony, but it had to be cleared up by the judge. So when it comes to trust, just know that it's something that it happens. You're not going to avoid stuff sometimes. So just crazy stories that happen. Um, you have situations where I had one where mom died. There were 7 kids, and this is no estate planning. Okay, so this is going to wrap your brains around multiple times. Mom died. She had a primary residence in Florida. She had 7 kids when she died. 2 of them had predeceased her. Of the 5, one was locked up, and one was just lost it in the brain. And so there were power of attorneys for both of them. And of the 2 that predeceased mom, one had 3 kids, and then the other had 2 kids. So you're thinking, whoa, I mean, that could have been totally avoided had there been some kind of estate planning done. Because if all mom would have had to do is say, I want you 5 to get it, the 2 others that didn't live, nothing happens with them, and it would have been a simple situation. But it was crazy because of the 2 that died before, it immediately went down to their lineal descendants, and being 2 and 3, and it being homestead property in Florida, all signed the real estate contract, all signed probate documents, and all had to sign the closing deeds and HUD statements for the title company. So that was a crazy story about what happens when you don't have an estate plan. Fortunately, they all got along. So that was just a fortunate story. And then the other one was where mom, there was a sister. The lady was not survived by a spouse. She was not survived by kids, grandkids, great grandkids, parents already gone, but there were brothers and sisters. And so what was known at the time was that there were 3 brothers and sisters. They all got along. We're about to get court orders. And the next thing you know, the question was, what about the other 3 brothers and sisters that died before her? What? And we were just like, wait a second, what 3 other brothers and sisters? So we found out that there were that predeceased sister. One had 1 child, another had 1 child, and the last one had 5 children. And fortunately, they all got along. Everybody was okay with each other. I came in on a Saturday from 9 to 3, pumped it out, was able to get everybody signed on a waiver that agreed to do everything. And eventually they all closed 2 months later at the title company. And then you're thinking, whoa, what a mess. Like, why didn't they just do a will? Well, why didn't they do a trust? Why didn't they do estate planning? But at the end of the day, for both of these crazy probate 2020 stories, I do what I do, and one of them was done in 8 days, and then the other was done in about 2 to 3 weeks. So you're thinking, whoa, that the timing on that is like definitely not 6 to 12 months. Again, I could have put slides here that talk about times that I've gotten probate done in Florida. Clay County was 1 day. There was one in Duval before tax deed. It was done in under 24 hours. There's been stuff done in Hillsborough in 2 weeks. Miami was 8 days. And sometimes it can be a month, or if there's known creditors, it could be 2 months, 2 to 3 months. But the probate doesn't have to take 5 to 10 months to 2 years. So crazy stories that come up from time to time. I've had foreign death certificate stuff that's come up from time to time, but those are the craziest stories I've had this year. I practice in the state of Florida. We do estate planning here. I don't do it personally. I have another attorney, Jeff Bankston, here that does the estate plan. If that is something that is interesting to you, I can set you up with the consult. I do all the probate. I do weird stuff like partitions, quiet titles, the weird, the different. Yes, we do the auto accident, personal injury stuff here too. But a lot of my specialty is the probate world and the trust admin world with different real estate litigation. So yes, I practice anywhere in Florida. Depends on the situation happening, whether I'll take on the case or not. But Again, this is my phone number. This is how you reach me. And that's my email address. So make sure you check out both, or if you want to snapshot both, that's how to get me. And again, you can find me on my YouTube channel at Al Nicoletti. I'm there. You can find me on my Facebook and just add me on there under my Al Nicoletti page. Also, I have a business page too, so check out the business page. You definitely want to like the business page, or hit the bell notification. I'm getting used to all this, Larissa. There's a bell notification so people get notified of when there's a post that I post out there. So make sure you check that out. And again, last but not least, check out the Al Nicoletti Show. I have just great people on there, tons of content, different things that you may like in the real estate biz, really focusing on real estate in Florida and business too. The more I do the podcast and I get up there and we talk, the more I'm like, wait a second, it doesn't even just deal with real estate, but it's a lot of business stuff that we get into. So it's just fascinating things. You can find me on iTunes, Facebook, Spotify, LinkedIn, YouTube, and some other stuff. I forgot where the other one was. It's just hidden. Oh, Instagram too. I'm on Instagram. So yeah, check that out. And thank you again, Larissa. Thank you so much for having me. And I hope that was a wealth of information for people that are watching this, especially in Florida. So thanks again.
Yeah, absolutely, Alan. Before I let you go, I did have two questions that I wanted to see if you would address. I have one where they are asking, just maybe a quick description of the difference between like a will and a living trust.
The quick description is that a trust avoids a probate proceeding if you retitle the stuff that you want to retitle. So like if the property's in your own name, you go to an attorney, you create the trust. Now once the trust is fully created, then you can go to a title company or the attorney and retitle the deeds so that the property is titled in the trust. Now if there's if you die and everything's laid out right, it's well drafted, upon death you avoid probate. Wills wills are just a way to make sure that, yeah, you understand that your family's still going to have to go through some probate proceeding, but you're picking where you want things to go, who you want to preside over your estate if need be. It's just they're two different animals. um One's avoiding probate and the other's not.
Okay, okay. And then also, can you legally disinherit a party if they contest the will? So I'm guessing this person is asking, so, if I leave XYZ to one child and not the other, and then I actually say in the will, if the other child should contest the will, then they get, less than promised or something like that.
Yeah, I think there's something against that in Florida, about will contests and putting contests in the will. I thought they were unenforceable, but that's something we'd have to look at too. I'm not in front of my notes as an attorney. What we always do is always research it and review that too, because I thought contesting will stuff in a as a clause, um, I thought that was just something that was unfavorable, but I
Okay.
would always have to look.
Okay. And then one more that I think is important to some of the people on for sure is if you have a property, it isn't located in the state of Florida, it is in Florida, but it's owned by an LLC. And they ask about California specifically, but I would assume that this would be true of any other, an LLC formed anywhere else. Are we still talking about Florida probate law?
Probably not. Not, yeah, probably not. Probably not.
Okay. Okay. Okay, so let me just look at the question really quickly. The question box. So there's a lot of questions on here, and guys, we're just sort of out of time. So what I'm going to suggest is maybe send Al a quick email, and talk to him maybe about a consultation if you have a specific scenario that you do need help with. I do want to thank Al again so much for joining us on here, guys. And this is recorded and it will be posted to our YouTube channel, so you'll have the ability to go back and review it if you wanted to hear the content again. And I hope to have Al on again soon. And we certainly could, I'm sure, go into a deeper dive on any one of these topics. But thank you so much, Al.
Yeah, again, thank you so much, Larissa. And I saw it was like people here consistently throughout. It was like steady 50 people. And I know people are tuning out now for lunch and stuff, but for those still listening, thanks again for being here. Really appreciate it. Again, this is a basic understanding for what the world of probate is, and trust stuff too. A little bonus there, Larissa. But I just wanted to make sure people had enough info there so they understand what's happening in the probate world.
Great. Thank you so much, Al. We'll talk soon.
All right, talk soon, Larissa.
Bye bye.